Good evening. Welcome to the 9th Annual Instructional Course Webinar Lecture Series from the Lumbar Spine Research Society. It's entitled Linking the Law and the Lumbar Spine. Next slide. My name is Mike Lee. I'm an orthopedic spine surgeon at the University of Chicago. Together with Jeff Coe, an orthopedic spine surgeon at Ortho NorCal, we're the program chairs for the LSRS Education Committee, and we will be moderating this session. CME credits are available for this activity, and you can access our website, lsrs.org/ICL, for more information on how to access those CME credits at the conclusion of the ICL series. Next slide. We have a great panel of speakers for this evening. So the first is actually Mr. Chris Stombough. This is a presentation scheduled for last week, but because of a last-second emergency, Mr. Stombough was not able to give his presentation, so we rescheduled it for this week. Dr. Jeff Coe did have a presentation scheduled for this week, which we will not be featuring today. Next speaker is Dr. Alexander Ghanayem, chair at Loyola University, orthopedic spine surgeon, giving a presentation on the lumbar spine surgeon as an expert witness. Third presentation will be by Dr. Jeff Rowe, orthopedic spine surgeon and CEO of IntuitiveX, and Mark Hahn, president and chief legal officer of IntuitiveX, speaking on intellectual property and building a non-clinical practice. The final presentation of the ICL series is from Dr. Richard Wohns, a neurosurgeon in Tacoma, Washington, founder and president of NeoSpine. Okay, thank you all for being here. We will please place any questions you might have in the Q&A function in the Zoom menu bar. We'll try to answer them during the presentations, but there will be a Q&A session after all 4 presentations have been given. So without further delay, I would like to introduce and welcome Mr. Chris Stombough. Chris Stombough is a plaintiff's attorney. He was a former president of the Wisconsin Association for Justice, which is a trial attorneys group in Wisconsin State. And I want to give him extra thanks for having the courage to be here in front of a panel and venue of audience potential defendants. So you and I have spoken that there's probably a lot of conversation and a gap that should be bridged. And so I appreciate you coming to us to start that conversation. He'll provide the plaintiff's attorney's perspective. So Chris, if you want to share your screen, that'd be great.
Absolutely, I'll do that. All right, good evening, everyone. I really appreciate everybody being here tonight. I'm going to give you a no BS presentation, I suppose, off the record. It would be a candid view from the other side. I would like to do this for purposes of basically our joint interest in patient safety and improvement of patient safety. That's really what my core interest is. And let's talk a little bit about what you expect that a plaintiff lawyer might say. And I'm going to give you some real ideas of what we actually are looking for in cases to prosecute, and some, I think, some interesting facts and approaches. So let me start out a little bit. Let me see here. All right, I've been doing this for going on my 29th year. I'm fortunate to have a number of record verdicts and settlements in all different kinds of cases. I have a national practice. A lot of what I do is train trial lawyers around the country in how to try cases. And it's, as you'll see there, my special interest is in applied cognitive science, really how people make decisions and understanding what people do in that process, but even more importantly, how emotion drives things such as emotional contagion and things of that nature. Moving along. Now, you will see that there are the 3 things we need in most jurisdictions to make a medical negligence case. The first that you will see is the standard of care. Clearly an issue relative to the standard of care. It's a big fight in many cases, whether there was a breach or violation of the standard of care. But in reality, the vast majority of medical negligence cases are really tried on issues of causation, okay? However, that has very little to do with really what makes a good, if you will, medical negligence case to take to trial. And I want to talk to you very candidly about that. I'm going to start with who this person is, Clotaire Pye. Clotaire Pye is a French psychologist. He wrote a book called The Culture Code, probably more than a decade, almost decade and a half ago, almost at this point. What his basic idea and belief is that the codes are unconscious meanings that people give to a particular product, service, or relationship. This is important because it goes a lot toward really why it is that certain doctors are sued for medical negligence, and why lawyers are willing to spend fortunes to bring cases in the modern environment. And I'm going to talk to you a little bit about that. The reason why I'm really sharing this with you is that so you can avoid these kinds of behaviors. I would love it if I never had to be involved in another medical negligence case. And this is something Michael Lee knows about me, but I originally spent 2.5 years being as a pre-med student. And I think it was organic too that was my downfall, as it is for so many of us who are not doctors at this point. However, I intended to spend my life as a missionary doctor in South America or Central America. So this change of heart was a big problem for my family. And I had to explain to them that I would try to do the Lord's work in the devil's profession. And that is not a joke. We had some very serious disappointment in my decision not to go forward. But let's talk about this. I want to share with you the doctor codes. If you're not familiar with these, you probably aren't. One is that if Americans are over 50, the code for doctor or physician is hero, okay? And that takes us back to Marcus Welby. It takes us back to the expectations of it. But what Pye teaches, and what many trial lawyers have studied, as well as corporate America in terms of their product branding and development, is that the expectations that people who are 50 and over have for physicians is that they will be heroic, okay, that they will act as heroes under circumstances where they are expected to be, that they will do heroic things. That is a tremendous benefit and a tremendous burden for physicians. And we've discovered this. One thing, though, that will antagonize and make jurors very upset at a physician is when they are not heroic. So when you are the anti of a good code like hero, it will very much create almost a punitive aspect or atmosphere relative to jurors many times if the doctor is non-heroic. And I'm going to give some examples of that. But in particular, I want you to be thinking about this for older Americans, 50, I'm in that category as well, 50 or over. But here's the other part. We have what I would call code slippage. And that is that for Americans under 50, if you look to the right there, you see people working on a Model T in probably looks like the 1920s or 30s. That code is assembly line worker. That has everything to do with managed care. It has to do with the expectation of younger people for what doctors do, how they are to be treated when they go into the medical process and otherwise. So if you are dealing with younger people whose experience of medical practice is in the assembly line variety, then you don't have the benefit of the hero code. Maybe you don't have the burden of it in the same ways as well. Incidentally, the code for two other players in the medical negligence arena, nurses, is also very interesting because the code for nurse is mother. Okay, and so if nurses are uniformly popular, except for 2001, where paramedics and first aid responders were linked as the profession with the highest degree by Gallup, the highest degree or percentage for ethics and honesty. Nurses have been first every other year. So that is one thing plaintiff attorneys look at if they're wise in terms of, is this person somebody who I really need to have as a defendant in this type of case? By the way, just like where the doctor is non-heroic, if you have a nurse, if any of you recall Jack Nicholson's movie, One Flew Over the Cuckoo's Nest, Then Nurse Ratchet is a beautiful defendant for a plaintiff attorney because she's off code in a terrible way, and people will want to punish that when they see it. So moving on, who is Tommy Moore? Thomas Moore, those of you who are in New York may be familiar with Tommy Moore by reputation. Tommy had a $132 million medical negligence verdict in the year 2012. And I have him here because of his internal rule of the three things that you need to have a medical negligence case. Now, technically, a lawyer will tell you, it's going to be a breach of the standard of care which causes harm. But in that, what of course is true on a very superficial level. But let's talk about behaviors that are going to get doctors in trouble. And they are, the doctor doesn't know, and meaning that the doctor doesn't know something that he or she absolutely should know. Okay, and you don't need all three of these, of course, but any one of them is going to be very important. So if the doctor is incompetent or is practicing beyond the scope of his familiar practice in a way that it was unnecessary to do at the time, that's going to be a problem. The second issue is the perception on the part of lay people that the doctor does not care, okay? Where the doctor shows that he is or she is uncaring to the plight of the patient, does not respond in a way that a patient has an expectation, or that the vast majority of people who will look at this in focus groups, by the way, I have done countless and countless focus groups on medical negligence cases. And these things are very strong indicators of a favorable outcome for a plaintiff in litigation. The doctor doesn't care in one way or the other. And finally, the doctor, for some reason, can be perceived as not telling the truth, or the doctor lies. Now, I further know that the vast majority of doctors are highly ethical folks who don't have any of these issues. But I would like you to look at these and see, what do these things all have in common? What they have in common is a doctor who is not heroic in any way, that doesn't know what he's doing, or she. They don't care about it, and they're not going to tell the truth, or they've been proven not to tell the truth on something, in fact, great or small, but something that may be important in the case. So what a lot of this boils down to is an issue of having a bad motive. If jurors care about motive almost more than anything else, they are intensely focused on it. Focus group participants just the same. And we do a lot of neutral type focus groups where the focus groups are unaware of what side of the case that I'm on, and I act essentially as just a facilitator of information that they have. And if there's something which would show that they had a bad motive, or a reason which was non-heroic for doing or not doing something that the physician needed to do under circumstances, it's a real problem. So once again, ask yourself, before any of these sorts of things happen, will this make me heroic or the opposite? That is clearly an issue. If you want to be on the best side of a situation, do the right thing relative to how people are going to look at this later as it may be exposed. Next, one of the issues that I want to talk, this is an article that I wrote for Clinical Orthopedics and Related Research. It's called Blowback: The Unintended Consequences of Medical Liability Reform. And what we have here, and what's important, is that despite the emotional and physiological effects of being sued, we have 5% of physicians have made at least 2 malpractice payments, and up to more than 50% of all malpractice payments. Okay, 2.3% of doctors have made 3 or more, accounting for 32.8% of malpractice awards. So it's the idea that things are out of control is just not supported by the facts. Another article pointing this out, frankly, was something dealing with the prevalence and characteristics of physicians prone to medical malpractice claims. And yes, there are some key, some areas where your area of practice will have some influence, but is by far not the most important. As we see here, 1% of all physicians accounted for a third of claims essentially. Only, physicians with paid claims, only one was in 84% of the cases. But then we had 4% had 3 paid claims, accounting for 12% of claims. So what we have here is a situation where very few physicians are accountable for most, or just an incredibly disproportionate percentage of the cases. And when we get back to the heroic side, I want to talk to you about a particular incident. And I had involving a claim against an orthopedic surgeon, which actually, in my practice, in the practice of most lawyers who do this that I'm aware of, is not very common. There are not tons of orthopedic claims that I'm seeing under these circumstances. But I had a client who came in who is, we'll call him Mr. Apple, to an orthopedic surgeon in the middle part of this country, affiliated with a pretty significant hospital, who was in his 60s for a very run-of-the-mill spinal decompression operation procedure. According to the operative note, it was absolutely fine. The nurse notes, though, show a different story, because right after the procedure was done in the recovery room, the nurse noted that the patient was complaining that he could not move his feet or legs. There was a note that was in the chart eventually from the nurse indicating that she had told this to the physician involved. That was not found initially, but it was there. The doctor, after receiving this information from the nurse, went and dictated the operative note, and he left for the day on a Friday afternoon. The physician, of course, is then reached again regarding this, and he orders that the patient be put on steroids. And he says, "I will see him tomorrow." And of course, by the next morning, with the hematoma in there, it was far too late for that patient. But what do we have there? We have a trifecta of this situation. We have a doctor who did not necessarily know what he was doing under the circumstances. This was, in fact, the second time that had happened to this physician. He clearly did not care for this patient, or at least could be perceived as not caring for this patient under the circumstances of this case. And he indicated that no one had told him anything about this until far later on Friday. The aspect of this really is you have all three of these things together. What we know then is under the bell curve, under standard deviation, I will quote myself by saying essentially that the bell curve operates in all professions. It doesn't matter if you are a lawyer or a plumber or a physician. And it should work out this way, because those very tiny percentages that I was talking about as creating almost most of the vast majority of problems are on the far right end of, or far left end, however you want to look at it, of this, which are 0.1% or 1 or 2 or 3% of physicians under these circumstances. So, what do we know at this point? I guess my challenge to you is knowing what we know. For this system, the tort system has to function for most of the medical disciplinary situations to also be activated either by a settlement or a verdict. Fewer cases means fewer events reported. And there are fewer cases largely because, as I've indicated before, because frankly of the success of medical negligence reform in certain areas. But what that means is that we also have a small number of physicians who are operating often without any sort of reporting of events by anyone. And that means dangerous doctors keep endangering patients. They're a small minority. They're a small minority in my profession. They're a small minority in every profession. But the sad part is that you already know pretty much who they are. My daughter is an emergency room nurse at the University of Wisconsin. She just left to start their life in San Francisco. Other members of my family who are in the medical profession already know who the physicians are who should be seen for particular issues, who should be avoided. I'm asking you that the challenge really is we need to have medicine help itself in these cases. We don't need a growth in claims by physicians who who are not worthy of the title. And it's a small number, and the vast majority of you are doing great work. And I salute you. So that's what I have for tonight.
Great, thank you, Chris. That was very interesting, and hopefully we'll get some discussion afterwards. I'd like to go into the next presentation by Dr. Alex Ghanayem. Chris, if you're able to stop share, and Alex, if you can share your screen.
I will do that.
Dr. Ghanayem is the chair of Loyola in Chicago. He'll speak to us as a spine surgeon, as an expert witness. Alex.
Okay, thanks, and happy to be here this evening. So I do some expert witness work. I wouldn't call myself an expert in that regard, but I'm going to tell you what I think I know. So disclosures, I've had some board and committee positions for the FAOA and CSRS in the last year. I have no standing relationships with any insurance carriers or law firms. So why would you want to be an expert? And I think if you love to talk, if you're really smart, if you're one of my cutting edge spine surgeon friends, if you think lawyers are really dumb at medicine and you want to earn lots of cash, maybe you ought to think about being an expert witness. And if you do, you'll be the unfortunate swimmer in the ocean and not the shark. Because those are not the characteristics of a really good expert. So, I think my role as an expert is a participant in the legal process, which is set in this country, and it is what it is. I do both plaintiff and defendant work, and if you're the plaintiff expert, you're the plaintiff's medical voice. If you're the defense expert, you're the defendant's quality control expert. Regardless of what side you're on, you get to define pertinent issues. And if you do that honestly and ethically, you actually play a role in framing the case and moving things along, either for dismissal, for settlement, or prepping it appropriately for trial and eliminating all the noise that may surround a case. So what are the skills you need to be an expert? You need to be an extremely careful listener. You need to take complex issues and convey them in the simplest of terms, because this is not grand rounds. You're not teaching at a course for other spine surgeons. You're talking to judges and attorneys and insurance adjusters in the beginning, and then eventually a jury. And so, breaking things down where people understand the concepts in ways that they could relate to. If you have an adversarial personality, this is an adversarial process by design, but that personality is bad. And so if you can't control your temper or your blood pressure, if you need beta blockers on a regular basis, don't get involved in this. You need to be quietly confident, and you must be someone that never fears the truth, and you need to be able to express that truth regardless. So, whose side are you on? I mean, we had a slide earlier of Lady Justice, and this is me. This is, I'm not Lady Justice, I'm more like Laddie Justice. And, I think, you need to be on the side of truth and ethical about it. I know some of my colleagues only do defense work, and some of my colleagues only do plaintiff work. I think, if you pigeonhole yourself into one of those only categories, you become an activist or a crusader. And I think your value in the community as an expert becomes diminished. If people know you're going to call it like you see it, and are willing to, stay on the straight and narrow, regardless of what side it is, then there's value in what you do. So that's my personal opinion. I know others may disagree with me, including some prominent members of some of our spine societies. So there are some prerequisites. You have to understand the local laws that govern your role, and they are different whether it's federal versus state to state. I know, for example, in the federal arena, you need to keep track of cases where you've been an expert and disclose that list. I don't do any federal work, and state rules are different state to state. You need to aggressively assess any conflict of interest. So any relationships you may have with either defendants or plaintiffs or medical centers that are involved. You need to really look at those carefully and disclose those to the person that might be retaining you. And if there's any potential conflict, then you just need to excuse yourself and move forward and get out. If you're a member of the Orthopedic Academy or the AANS, you really need to look at their standards on professionalism and their expert witness programs and be compliant to those, because the last thing you need is to be called before their professionalism committees for a violation, which threatens your profession in existing as a spine surgeon. So look at those, understand them, and stick to them. And, this is a talk about being an expert, but if you're a treater, you want to avoid being converted to an expert. And what does that mean? If you're a secondary treater in a malpractice case, testify to what you see. I mean, it is what it is, what your operative findings are, what the patient's conditions are. But if one side tries to get a standard of a care opinion out of you, you don't have to have an opinion, and don't get converted into an expert. And they may hammer you, but you can fall back on those expert witness plans and standards of professionalism, where you can say, listen, I haven't looked at the complaint. I haven't looked at the deposition transcripts. I haven't looked at all the records. And because I would need to do that to offer that opinion, I'm not going to offer it, and keep yourself out. And for your younger surgeons, that's really important to do, so you don't get converted into something you don't want to do. So when you engage in this process, you need to define what you can and cannot do for the attorney that's engaging you. What I do is I review the case from the opposite perspective. I play the devil's advocate, with myself when I review these cases. I try and get in the head of the opposing side. It makes my review much stronger. And to the person that's retaining you, you need to expose all real and potential weaknesses. Don't sugarcoat things. They'd rather hear from you that they don't have a case than get into a problem down the road from the opposite side. And so you may end up telling them things they don't like, but that's okay. I mean, that's your role as an expert, is to expose those issues, and so that the people that have employed you can make good decisions. So with my opinions, I try and create a box or a wall, a fortress around them. And there's four components that they are the standard of care, real-time decision-making. I forget what I do in my practice, and I divorce the outcome. And I build that wall around my opinions as we move forward in order to keep control of the process. So the standard of care, I mean, first of all, there's no authoritative sources. There are zero authoritative sources. White papers, society guidelines, review articles, book chapters, peer review literature, they are not authoritative sources. So, just pound that into your head. Guidelines are just guidelines, and variations are simply that, variations. Variations from guidelines are not standard of care violations. And, the whole science versus art. Yes, medicine is scientifically based, but it's also an art. And you need to, embrace that as you move forward in your reviews. So when you're asked to be an expert, avoid, when I do this type of case, despite what your parents tell you or your spouse, you are not the only reasonably qualified physician in the world. And so you need to, particularly as a defense expert, embrace diversity. And, a technique that I use is I actually embrace the opposing expert's opinion. And I do that on both defense and plaintiff sides. And so what happens is, if you embrace it, the fight is no longer with the expert. The fight on a defense side is whether or not there are other ways of doing things. And so you've deflated, the other expert. If the other expert says, I always do X, then Y, yeah, sure, that's fine. But it's okay to do A, then X, then Y. And build that variation and that diversity into your opinion. So it helps deflate the opposing side. And then I just told you earlier that there are no authoritative sources, but I still tell you to embrace the literature. And why is that? Well, pick a number, like a success rate after a particular operation. You'll find an article that says it's 90%. You'll find one that says it's 80%. You'll find one that's 50%. You'll find one that's 30%. It's all over the place, okay? And that's a problem with our literature. But on the other hand, that's the variation in our literature. And use the experts' literature. Go to the reference list on the opposing experts, articles that he cites, which is a mistake, and you'll find variation that'll help impeach that opinion as the only opinion. Divorce the outcome. So, the proof is in the pudding and justifies the means. It didn't work, so the decision-making must be wrong. None of those fly. And you have to work hard. Yes, bad things happen, and you have to be empathetic toward that. But the bad things that happen aren't happening because something bad was done. So, you need to use the literature once again to illustrate the range of outcomes. But once again, there's no authoritative sources. So the hard thing is, being a Monday morning quarterback. Now, Howard Cosell was famous for Monday Night Football, and was told one night, I think it was his partner in the booth that said he had a firm grip on the obvious. But you need to critically evaluate every action, every decision in a vacuum relative to its outcome. Was the decision made appropriately for the information at hand at the time, and then move forward from there. And it's hard to do because something happened, and it may not be a great thing that happened, but was the decision sound? And that's how you have to do that and convey those messages. So in the process of being involved, I mean, you're going to get some email, phone call asking you to be involved, and they're always going to ask you for your fees, and you give them those in writing. And they are what they are. Don't be embarrassed by them. Opposing counsel will ask you about those on the record. They'll try and make a big deal of it. And actually, most of the good attorneys on both sides don't really care, because they're retaining an expert, and the opposing side has an expert. And guess what? Everybody charges for their time. So it's the ankle biting attorneys that really focus on and trying to embarrass you on your fees. Don't be, and just move forward and be done with it. Manage expectations, find out what they want from you and what you can deliver. Review the complaint in the beginning, and disclosure of potential conflicts of interest. And if you can mitigate those and you're happy with everything else, then you can get involved. The record review should be thorough and complete. I would suggest that you always review the actual diagnostic imaging and not the reports. Do not rely on reports, and that has to be something you do independently. You have to review deposition transcripts, and their usefulness varies. And so, physicians, nurses, talking about what they did in real time is important. The patient, their perception is always a little bit off because of where they are in this case. The family member that was in the room, usually not very helpful. Review them, but you got to stick to things that are hard evidence in the process. Always remain empathetic. Never say that the patient was wrong in what they thought. It's just it's a non-starter if you do that. So at some point, there'll be disclosures and responses to interrogatories, and so you've got to review what they're saying about you on those documents. And so make sure you're comfortable with what they're saying you're going to testify to. And leave yourself some wiggle room. In general, it's to be expected, because you want to be able to respond to things that come up that are unexpected. So the next step in the process is the discovery deposition. And so it really, it could be a legal colonoscopy, or it could be a legal CAT scan. I prefer to have a CAT scan than a colonoscopy. It's your choice. And that really depends on what you do, whether you're prepared, and you have to prepare. You have to be so prepared. Looking at stuff the night before is not the way to prepare. I always, I like the saying where you use your ears, your eyes, and your mouth in proportion to their number. So a lot of listening and a lot of watching. Watch the body language, watch the note taking, and then when you speak, answer the question, and don't get off on tangents. You need to be respectful, but you need to be confident. A little humility goes a long way. Now, occasionally I'll have to, change the tone a little bit, but that doesn't happen with most of the attorneys I work against, because it's a respectful relationship. Don't get lulled into drawn into traps. The country lawyer that says to you, "Yeah, doc, I really don't understand." He understands, okay, or she understands, and so don't fall into those traps. And then finally, be able to articulate some verbal clues to your attorney that you're working with on issues that you may want to explain if you don't like the way you have to answer a question. And the classic, Groucho Marx for $20, have you stopped beating your wife? Well, if you answer that, yes, you've been beating your wife. If you answer it no, then you're still beating your wife. And then finally, a trial, you must be prepared. I think you must attend. You have to be presentable. I could be humble, despite what some of the people in the audience may think. I can do that. But remember, you're being questioned by attorneys, and this is a conversation with the jury. And I think that's the most important thing you can do as a physician. So I'll leave it at that and move along. Thank you.
Great, thank you, Alex. Moving on, I'd like to introduce Dr. Jeffrey Rowe and Mark Hahn from IntuitiveX. Dr. Rowe is an orthopedic spine surgeon in Seattle, Washington, and also the founder and CEO of IntuitiveX. And Mark Hahn is the president and chief legal officer of IntuitiveX. Mark, if you're able to share your screen. And
okay. Great. Thank you so much to Mike and Jeff for inviting us. Thank you to the organizers of the LSRS. We were asked to give a talk on intellectual property and building a non-clinical practice. And we're going to sort of highlight this by talking about some of the breakthroughs that we've been attempting to accelerate. And it's really about innovation. And if you think about what happens with innovation, it takes people, it takes expertise, and it takes time and money, to tell you quite honestly. And that's what we aim to do at IntuitiveX, which is our life science incubator and consultancy that we started about a little over 5 years ago now. So what we do know about the life sciences, if you've done any work in medical device, pharma, biotech, or even digital health, you'll find that that it's quite different from innovation within the tech space. And in that, in technology, you can get by with a full stack engineer and a business person and raise a little bit of capital and really be able to get to what's called a minimum viable product, or an MVP, a prototype essentially in the digital space, and then be able to test and validate that model very quickly. Well, especially in those first three industries, including med tech and pharma and biotech, it's very different. It's quite expensive, not only because of the clinical trials that they often require, but also because of other factors such as regulatory, as well as trying to develop a prototype that you may have hardware as well as software involved with that. You might have a compound, you might have a drug or a biotech, and it becomes quite expensive to try to develop a product or service within that model. It's also quite time consuming because of the fact that there are so many sort of hoops and regulatory aspects to go through. So instead of trying to develop something within about a year or two, it can be as long as 5 to 10 years in some cases. And finally, quite honestly, it's confusing. And to tell you quite honestly, being a clinician or a scientist and trying to start up a company and trying to commercialize a product or service and bring it to the marketplace can be very confusing because of the fact that traditionally we don't have much experience running companies or doing business. We don't learn that in medical school or in undergrad either.
This is Dr. Richard Wohns. He's a neurosurgeon in Tacoma, Washington, and obviously an MD, but also an MBA and a JD. So kind of relevant to our whole theme of our ICL, linking the law with lumbar spine. He will speak to us on legal and ethical relationships with industry and corporate America. Richard, take it away.
Thank you, Mike. Thank you for inviting me to speak tonight. I'm going to cover a lot of ground in a hopefully rapid rate, but still palatable to the audience, particularly given the time that it is east of us. So I'm going to cover mostly the theme is conflicts of interest and talk about the legal and ethical relationships in a number of different settings. So the first setting I'm going to talk about is my own conflicts of interest, and here they are. And then here's the list of what we'll go through: consulting agreements with industry, the Sunshine Act, Anti-Kickback Law, POD, Stark Law, Medicare Fraud and Abuse, False Claims Act, Direct Hospital Employment, and included in that is the Corporate Practice of Medicine Doctrine. Consulting agreements are very important because they're things that are very interesting to doctors, very highly competitive to work with different companies, and physicians really need to know what they're getting into when they sign up to be a consultant with a medical device company particularly. The advice is making sure that everything is in writing, signed by both parties. The consulting agreement has to be 1 year, no less. The compensation has to be stated. And the key thing here, without going into all the detail in this slide, is that it has to be at fair market value. You can't have some incredible sum of money that's being transferred from a medical device company to a physician without breaching the consulting agreement standards that will be looked at in great detail if there's a legal challenge. The Sunshine Act covers those sorts of legal challenges so that any arrangement you have with a medical device company, also with pharma, biotech, et cetera, has to be federally available and reported. That's the Sunshine Act. So everything has to be disclosed by the company. The physician gets to look at what's being disclosed on the website and can challenge the accuracy. So payments, items of value, and any stakeholder, shareholder interests that are transferred to physicians or their immediate families, that's all posted on the Sunshine Act website. So this is critical to be accurate because this can come back and haunt somebody and be used against you in the future if it's not properly done. This promotes transparency in the industry and transparency amongst physicians. And it's critical when we look at some of the other things that we have to face, which are some of the big federal statutes, such as the anti-kickback statute. And we'll talk about this, and then we'll talk about Stark. So when you're working with industry, the anti-kickback statute prohibits knowing and willful solicitation, receipt, offer, and payment of anything of value in exchange for referral of business. So if you're consulting, you're out of the realm of referring business, such as to your own healthcare facility or a company that you have ownership in that is producing a device that you're using in a hospital setting or in a surgery center. So this is a very important statute to know. If there's an anti-kickback allegation against you, if you're the developer of IP, using your own IP in a hospital setting or in an ASC and not disclosing ownership, and you're getting royalties or payment for use, you're potentially in significant trouble, particularly if you use the devices that you're making money on for federally insured patients. So let's go into this in a little more detail because there have been numerous physicians and surgeons who have gotten into trouble in the last few years in an escalating number and going to jail, paying huge fines, getting on the front page of newspapers for a breach of the anti-kickback statute. So you have to know safe harbors, and you have to know what it takes to escape an anti-kickback allegation. A safe harbor creates narrow but attainable exceptions. Space rental, equipment rental, you can see the laundry list I have here. Ambulatory surgery centers, major feature of a focus for the past 10 years and escalating in the present day because with COVID, more and more hospital work has been shifted to outpatient facilities, ambulatory surgery centers. And the good news that it is a safe harbor So it has protected a lot of physicians in their ownership role of having an ambulatory surgery center. Failure to meet a safe harbor does not mean that the activity is necessarily illegal. So in this setting, anti-kickback is more for use of medical devices and implants and DME, and we'll talk about that because this is particularly what's getting people into trouble, not ownership of a surgery center, not an investment in a medical practice. The key thing that's getting people into trouble related to anti-kickback, as I alluded to a few minutes ago, is owning devices, owning a physician-owned distributorship. This has caused a lot of people a lot of problem. So what is a POD? A physician creates a holding company for distributing medical devices, and it can be IP that the physician has generated or just an arrangement with a medical device company so that the physician then controls when and where the devices are used and essentially makes a profit each time a device is used. And if that is the way the business is transacted, there are very questionable features to the development of the POD that need to be known. If you select investors in your POD because they're in a position to generate substantial business for the entity, and then let's say your investor no longer practices in the area and you require them to divest interest, and then you distribute extraordinary returns on the investment, these are the questionable features of the POD that brings OIG attention to your POD. The other thing, as I alluded to, if you do not disclose to the hospital where you're working that the reason you're using a particular device or an implant is because you're getting a profit, a kickback, and you don't disclose to your patients that you have either intellectual property ownership and you have royalties, or you don't have any intellectual property, but you get a kickback for use of that particular device that you're implanting in the patient, or you're encouraging other people to implant, you're going to be looked at by the OIG, and there are significant damages that you'll end up paying and fines, potential loss of your medical license, potential incarceration. So this is a major red flag issue that I wanted to bring up related to anti-kickback. So how does that differ, anti-kickback, from Stark? Stark regulations are generally more stringent. Stark compliance will entail anti-kickback, and Stark exceptions are mandatory. If the Stark law applies, failure to come within an exception means that the activity is prohibited. The scope and purpose of anti-kickback and Stark are different. So let's look at this a little more. Stark law, and this is an elemental analysis that's done. It states that a physician who has a financial relationship with an entity is prohibited from making referrals to the entity for provision of designated health services for which payment may otherwise be made under Medicare. So this is an elemental analysis, as I said. The physician could be an MD or a DO, or it could be a member of the immediate family that has the ownership in whatever entity is creating this profit stream. If the MD is doing it on his own, the hospital group or the medical group, who's not technically a physician, stands in the shoes of his or her group practice. The physician stands in the shoes of his or her group practice. So the hospitals and the medical groups are subject to the legal exposure by the physician's activity. In other words, a relationship with the medical group becomes a direct relationship with every physician owner of the group. The Stark law includes designated health services very specifically. And as you can see here, it includes all the things that we do on an everyday basis. But again, ASCs are exempt. They're exempt from Stark, and they're exempt from the anti-kickback. There's some new exceptions to Stark and anti-kickback that have become very prominent due to value-based medicine that's become popular in the last few years. So there's essentially now, even though Stark and anti-kickback are very strict at preventing physician ownership and physician profit streams, there's more opportunities for physicians to receive compensation when it's a value-based care that they're prescribing, or if they've set up or they've developed a particular way of increasing the quality and value-based care for their patients with at least 10% downside risk. So this again benefits ASCs, which are important in value-based arrangements as a lower cost of care site of service. Moving on, basically I'm full of bad news tonight, but these are important things for physicians to know, because if you don't know them, you can easily get into trouble. And Medicare fraud and abuse has a big history around the country. And particularly in Seattle, there's a well-known neurosurgeon who ran afoul of Medicare fraud and abuse, not Stark or anti-kickback. So this is purposely billing Medicare for services that were never provided. This is upcoding. This is unbundling. This is soliciting or offering, receiving a bribe or kickback, or billing non-covered services. Medicare fraud and abuse is a thing that you do not want to run afoul of. A False Claims Act is a cousin of the Medicare fraud and abuse law. False Claims Act basically states that if you knowingly present or cause to be presented a false claim for payment or approval. So basically a Medicare fraud and abuse allegation entails a False Claims Act. If you unknowingly make or use a record or statement material to a false or fraudulent claim, and you self-disclose, you can get off the hook. And the OIG states that if you voluntarily disclose within 30 days of the event that you discover in your own practice, and report and return any overpayment for upcoding, overbilling, unbundling within 60 days, most likely you will be released from any liability by the OIG. Direct hospital employment, again, another phenomenon that over the past 10 years has become a majority way of physicians practicing. Private practice is dying. Direct hospital employment or large group employment has become the majority way of physicians practicing. It's important to understand the issues with hospital employment, the ethical and legal issues. There's the corporate practice of medicine doctrine. There's the concept of fiduciary duty to serve the hospital employer. There's the conflict of interest between the ethical duty to care for patients that we all have as physicians and the fiduciary duty to serve the hospital employer. So let's look more at hospital employment. So if you have a contract for employment, you have to have the deal at fair market valuation. You can't have built into it kickbacks or rebates or payment of unreasonable compensation or payment of referrals. You have to be paid at fair market value. The corporate practice of medicine also has to be understood because in some states, it bars employment of physicians. And that's in Colorado, California, Ohio, Texas. In most states, however, not-for-profit and for-profit hospitals are exempt from the prohibitions of corporate practice of medicine. But in certain states, it's a basically deal breaker for trying to create an employment of physicians by hospitals or large groups. The history of this, very briefly, is it was created by the AMA to protect the public, but it has created a situation where the divided loyalty and impaired confidence between the interests of corporation and the needs of the patient is really no longer protected when the corporate practice of medicine is not in place. And that's the majority of states. So the corporate practice of medicine is a good thing, I think. It prevents Sherman antitrust violations and limitations of patient choice, and particularly in situations where there's a monopoly. For instance, in underserved communities, one hospital system can take over the entire practice of medicine in an area. And what it does is prevents independent physicians from being able to practice. It prevents employed physicians from making free choice decisions based on patient needs. It really, the corporate practice of medicine is really a check and balance to protect the ethical patient care and integrity of the medical profession. And you lose it when there's a monopoly power exerted by a hospital system or a medical practice in an underserved community. I'll move on here. Direct employment allows control of physicians. Financial gain is an issue that could supplant the needs of patient care despite the ethics of physicians to primarily be caregiver, not profit center. So this is an ethical conflict of interest that needs to be concerned, a concern of all physicians who become employees. And in the states where it's not allowed and private practice is still the predominant way of practicing medicine, there's less of this ethical conundrum. The theme of my presentation tonight is, it's not doom and gloom, but it's really for education purposes to show that legal constraints on the practice of medicine need to be focused on conflicts, oversight, and due process within vertically integrated hospital systems and between physicians and industry, really for patient safety and patient care. The goal is to guarantee patient access and rights to care unaffected by corporate, contractual, financial interference with medical decision-making, and that lay control of medical decisions by either hospital boards or medical device companies, which cause divided loyalty in how physicians practice. Think about them as pawns, potentially, that if they don't know that they're pawns, their divided loyalty between being a good employee, running a successful physician-owned distributorship and trying to be a profit center, this divided loyalty has to be understood, and the patient's care and the autonomy of the patient with care provided by a doctor who's not being a pawn of a corporation is the critical thing. It's necessary to protect ethical patient care and the integrity of the medical profession so that we are not considered ways of big business achieving profit. Hospital administrators sometimes think that the most powerful tool in medicine is the doctor's pen, because they control what happens to the patient and can cause referrals in one direction or another, can lead to increased profit for the employer or for the medical device company. And so that's a dangerous tool. And so the physician needs to understand that he's in control of that tool and always be ethically bound by all the things that we went into medicine for. On that note, I will end my presentation and thank Mike for the opportunity to speak tonight.
Thank you, Richard. That's an excellent talk. I see a couple of questions in the Q&A. Please use the Q&A and we will almost certainly have time to answer those questions that you put in. I'm going to try to divide this. I'm Jeffrey Coe, by the way. I'm the co-chair of the Education Committee for the LSRS. I'm going to handle, the presentations are divided into two components. The first component was the medical malpractice, and the second is more the intellectual property and physicianal relationship issue. So we'll go with the first part first. I have a question for Chris. So Chris,
Hi, Jeffrey.
how are you? It's nice that I appreciate you coming to Lions Den and speaking to us. So as a spine surgeon, if I have a complication that may potentially be considered medical negligence, or maybe not, maybe it's just a bad complication, and maybe I did, we all have these things happen. We have all complications, and what's the best way for us to handle it to stay out of your claws, so to speak? What was the best thing? We got to do right by the patient. We want to, should we apologize for a medical error? How do we handle it? Give us the top 3 bits of advice that you give us for this sort of situation.
I think part of it is not to compound it. I think being upfront with the patient and their family is really necessary, because a lot of what happens is there's a very bad result and no one is talking to the patient. Okay. And there's no explanation for what happened, no understanding, no care. And if we're talking about what Tommy Moore would talk about, if the patient doesn't care or appears not to care, I think it's an issue. Physician apologies has made the rounds, as it were, in many states, and I acknowledge that can help in certain situations, but I think part of the issue is being transparent about things, acknowledging when there is a complication, explaining the facts about that complication, and I think being heroic. I'd like to use that term again, because I think there is something to it about being a stand-up human being. And I think if you leave the person, feeling abandoned in the process, that's where you're going to begin to see problems.
Great, thank you very much.
Can I ask a question, Alex?
Go ahead,
Alex,
Mike.
Standard of care, you mentioned there's no authoritative source. So as an expert, how do you address the notion of a standard of care when attorneys ask you if something fell within or outside of the standard of care?
Well, the standard of care exists on a continuum. So it's not a binary answer. And so while there's no authoritative source, there's no one source that defines it, you can come to a conclusion regarding whether something met the standard.
I have another question for Alex. You gave in your talk that as a treater, you should, and if you see an opinion in which the attorney might be fishing for an expert, that you should avoid that. But in some cases, if you do see a patient and you want to be involved, is that something you could consider from a time-to-time basis, or does it say, well, you should never be involved as a treater categorically as an expert in a case?
No, I think the message there was for people that don't want to get dragged in, because if you're going to convert yourself into an expert, you're doing more than just telling the story of what you saw, and so there are standards of testifying. If you're a member of the academy or a member of the neurosurgical academy, and you've got to meet those standards, and so you don't want to be missing a whole block of information that may change that opinion, and so you just have to be careful.
Great, thanks. We have a question for Dr. Wohns from the Q&A. Do surgeons need to disclose their role in a medical advisory board to patients? Does this vary by state, or is this a federal mandate?
Richard, if you want to comment
Medical
on the prior-
Advisory Board.
Sorry, go ahead.
Sorry, Mike, go ahead.
I was just going to say, if you want to comment on the prior questions, you mentioned that you had a comment or two, so feel free.
Okay. Yeah, I could start with question number one. In the state of Washington, there's a I'm sorry 30-day protection, so that if you have a bad outcome, you can say I'm sorry to the family and really, placate their hatred or their madness or their desire for information, and that's not discoverable. You can say whatever you want during that 30 days. So that's a really good feature, and that's catching on around the United States. Second thing on the expert witness standard of care is that the magic words are what a reasonably prudent surgeon of the same type would do in the same situation anywhere in the United States. So that's what defines the standard of care, really, and those are the magic words used in court when the question is, what is the standard of care on the issue? So on the third question, which was, do you have to disclose your medical advisory board position to patients? If it entails activity related to their care, such as with a company whose devices you're using, or equipment that you're using, or a procedure, yes. And then you have to make sure you let them know, but I'm not going to get any royalties or payment when it's used on you, my patient. I am not going to make any money, and you have to disclose that. Same to your hospital. If you're on the board of a company and you're using their devices, you need to let the hospital know that the device is being chosen by you. There's a conflict of interest, and if you have them understand that, they'll say that's fine, or they'll say, no, you can't use that device, you have to use another company. That has to be a discussion to be above board 100%.
Great, thank you very much. I have a question for Jeff Rowe. Apart from just signing up with IntuitiveX, if a young surgeon has an idea they can consider innovative, and they think that they want to possibly patent that idea, just generically and step by step, what are the processes that you do to incubate that idea?
I mean, first and foremost, I would definitely protect the intellectual property. So typically, when you do a kind of an assessment of whether or not the idea is unique and novel, what you'll do is you'll approach an intellectual property attorney like Mark Hahn, and unfortunately he had to jump up because I think he had to take care of his kids. But it's essentially they'll do a prior art search to see whether or not there's a similar type of prior art in the USPTO's database, in USPTO's U.S. Patent and Trade Office. And then a good IP firm will also do a landscape analysis to see what other types of technologies and similar intellectual property there are. And then finally, if they're really comprehensive, they'll do what's called a white space analysis and determine areas where you could actually protect around the existing IP to have the freedom to operate in the space. But I would absolutely do your homework and research on the IP firm, because just like the quality of the surgeons, there's quite a bit of variability in the quality of IP firms and IP attorneys that are out there as well.
Great, thank you very much.
Could I comment on one
Sure,
thing?
absolutely.
I think it's absolutely imperative, though. I would like to encourage more orthopedic surgeons to be experts in, let's say, the non-medical negligence field. The reason for that is that I think there are so many cases involving our clients and your patients, and I'm once again outside of the non-medical negligence. Let's say orthopedic surgeons deal quite frequently with people who are victims of trauma from various scenarios. I think if you look at it from using an epidemiological aspect, at least with respect to causation, where there's biologic probability, there is there's a temporal relationship between what happened and the care that was given and the need for it, and that there's not a more likely cause to it, then one can generally say, using principles of science, that something is the best explanation for given facts. So my sense is that often lawyers are terrible at explaining, causation relative to even from a scientific basis, and that causes some problems where people are going essentially based on feel. So I guess I would encourage more orthopedic surgeons in cases where they're not, especially, where it's not a heavy lift and where a tremendous amount of background is necessary to link their care with particular events, to participate or at least be open to doing so in the non-medical negligence areas. I understand in medical negligence, that's a whole different can of worms, as it were. So that I feel strongly about that, and I just wanted to encourage people to at least keep that open.
Great, thank you so much, Chris. So are there any other questions from the panel, to other panelists? Because I see nothing in the Q&A. We're right on time to wrap this up. Great, well, I think that'll bring this instructional course to a close. I'd like to thank all the speakers for taking time to prepare their talks and participate. Very educational. And we will see you at the next LSRS meeting for those of you in attendance. And I'm, as of now, I'm off this committee, and I wish Mike, his co-chair, for whoever the next co-chair is for the LSRS Education Committee, good luck. All right. Thanks so much, everybody.
Thanks, everyone.
Good night, everybody.